Good day, Crime Talk aficionados. We have a great show for you today. First, the prosecution objects to a crime scene visit in the Delphi murder case. The Trump alleged assassin pleads not guilty, but is still trying to get released. Sean Combs is apparently much better now, so no need for that suicide watch. The Sarah Boone cluster, continues. The teen who was convicted in Mississippi files a motion for a new trial based upon new information and makes you wonder, were the attorneys ineffective? Guess what the pediatric assistant is accused of doing? And do you really need a dental license to be a dentist? Political rhetoric can get out of hand, but this language will get you charged. We have This Day in Legal History, and then finally, our Dumb Criminal of the Day. Let's talk about it.
Hi, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below about what we talk about today. Hit that little bell for notifications. And yes, you can always check us out on any of your favorite podcasting apps. Now, before we get to the docket, please go to CrimeTalkSearch.com and sign up for that background subscription service today. You're going to be happy that you did. When you have that subscription, which you can cancel at any time, you can do a background search and you are going to be able to search anyone here in the United States. And you're going to get information as to whether they have a criminal history. Are they married? Are they divorced? Do they have civil judgments against them? Do they own property? And just an overview of this individual. In fact, you're even going to get an overview of their social media content. Gee, why does your husband have that second or third email account? What is he looking into? Check it out. Go to CrimeTalkSearch.com. All right, let's go ahead and open the record for Monday, September 30th, 2024. First, the prosecution in the Delphi murder case is objecting to allowing the jury to see the crime scene where police found the bodies of Abby Williams and Libby German. The defense made the request earlier this week in a motion to the court, and the defense also wants the jury to walk the trail from the Freedom Bridge to the Monon High Bridge to view where investigators say the girls were abducted. And the defense wants the jury to see where prosecutors claim Richard Allen parked his car on the day of the murders. Now, the special judge, Frances C. Gull, on Thursday said that she would wait until after the jury selection is made to make a decision on this motion. That jury trial is scheduled to begin October 14th, and it looks as though it will not be televised. That's very unfortunate. I think the state of Indiana and everybody else in the world who has been following this case should be allowed to see what evidence the prosecution has, whether they can sustain their burden of proof beyond a reasonable doubt to each and every element of the offense charged, or whether Mr. Allen will be found not guilty. You would think the courts would want the world to see the evidence or the lack thereof. It gives legitimacy to the court proceedings. Next, the Trump would-be assassin says, "I am not guilty." That's right. The alleged Donald Trump assassin, Ryan Wellesley Routh, has pled not guilty to several charges, including the attempted assassination of a former president. Mr. Routh appeared in federal court in West Palm Beach, Florida, this morning after being charged with attempting to assassinate Mr. Trump. He's been ordered to remain in jail without bail as his case makes the way through the court system. He faces a total of 5 federal charges after authorities say he pointed a rifle through a fence at Trump's golf course club in West Palm Beach, Florida on September 15th. Now, last week, prosecutors revealed that he wrote a somewhat damning letter to himself admitting that if you're reading this letter, he has failed in trying to take the life of a former president. Pretty good evidence that you had an intent to kill the president, but you failed, therefore it's only an attempt. And in that letter, Mr. Routh also offered the person who was going to get the letter $150,000 for anyone who could finish the job. Now, the Justice Department has taken some heat as to why they were releasing that information, because critics are saying that, well, that's going to put the president in danger if you get some whack job who's going to say, well, I'm going to go get the $150,000. I'm a firm believer in the truth, ladies and gentlemen. Listen, if there's nut jobs out there that are going to go try to assassinate somebody like that, they're going to do it, and they're not going to need the incentive of $150,000. Those are the facts. We argue for the facts to be released all the time. We argue for the truth to come out. And the truth usually will come out, but it only comes out if we're actually getting the truth and not some spin. Regardless of what side it is on, the truth and the facts are really what matters. Anyway, the letter states that this was an assassination attempt on Donald Trump, but I failed you. I tried my best and gave my all gumption I could muster. It is up to you now to finish the job, and I will offer $150,000 to whomever can complete the job. Now, for any wackadoos out there who think, wow, I'm going to take up this offer to get the $150,000, I don't think Mr. Routh has it, unless, of course, he was working for some alphabet agency or something like that. But that's just rumor and speculation for sure. Don't do it. Don't do it. You're not going to collect. Don't do it. That would be against the law. Do not do it. Anyway, like I said, the Attorney General, Merrick Garland, he had to defend making the letter public after critics said, you're basically putting a bounty on the head of the president. You know how I feel in that regard. The truth is always the best. We can handle it, ladies and gentlemen. We can handle the truth. The wackadoos are going to do what they're going to do regardless of what information is there. Now, Mr. Routh also had a list of Mr. Trump's upcoming public appearances, and it actually Googled a route of how to get out of Palm Beach, Florida, and make his way to Mexico. Once again, consciousness of guilt type of evidence that will come in at trial. Now, like I said, he is set to appear in federal court for this detention hearing and the arraignment, and the judge said, yeah, you're not going anywhere. The evidence that the prosecution submitted for the detention hearing was a proffer of new details about the day that Mr. Routh tried to assassinate Mr. Trump. In addition to outlining the evidence against Mr. Routh, the Justice Department argued that he should remain locked up as the case moves forward. Once again, that proffer included information about the letter, what they found at the house, and all this other stuff. Now, Mr. Routh's son, talk about a collateral consequence of engaging in this kind of information is that Mr. Routh's son, last week, they went and raided the house back in mid-September, and the son's now being charged with having inappropriate child kitty-ish photos on his phone, which certainly is not good for him either. Hey, I know you all are very concerned about Sean He Did It Combs, but guess what? He's okay now. He's been removed from the suicide watch at the Metropolitan Detention Center in Brooklyn, New York, almost 2 weeks after his arrest on the federal sex trafficking indictment. Now, apparently, he's had a couple of relatives that have been able to see him, and it's made him come back into focus. And according to his attorney, Mr. Combs is focused and very strong amid this incarceration, and he is concentrating efforts on his defense, and he's going to be preparing for trial. I hope you do, Mr. Combs. If you didn't do it, don't plead guilty. If you did, you'll see how the federal sentencing guidelines work, and you'll see that you're facing a minimum of 15 years to life in prison. You'll have those conversations, trust me. So if you don't recall, Mr. Combs was taken into custody on September 16th in connection with the sex trafficking and racketeering indictment, and he is set to appear in court early next month, where they're going to get some trial dates. Now, apparently, the suicide watch was put on Mr. Combs as his mental state appeared to be somewhat uncertain, and he appeared to be in shock after his arrest. But oftentimes, don't panic, ladies and gentlemen, oftentimes that is not uncommon. When people are going through the classification process at a new detention center, they may say something. They'll ask you, are you considering taking your life? And if somebody says yes, or I thought about it, guess what? You're going to get on suicide watch. So you get to sit in a little room with little paper clothes, and they're going to watch you 24/7. Suddenly, either A, you're going to try to do something, or B, you're going to say, I didn't really mean it. But now he's focused, because now he's going to fight this case. It's that initial shock of being arrested. But things are going to get worse for Mr. Combs, because he's going to have a lot of time spending it with his attorneys, not only his criminal attorneys, but his civil attorneys. Because guess what? He was hit with a new sexual assault allegation on Friday as a woman filed a lawsuit in New York saying that she was repeatedly sexually assaulted and drugged at the home of Mr. Combs, and actually became pregnant after one of the encounters. It's kind of the latest in several lawsuits filed against Mr. Combs by several women across the country. Now, the lawsuit was filed against Mr. Combs, his companies, and several associates, and seeks an undisclosed amount of damages as a result of physical injuries and severe emotional distress, humiliation, anxiety, and other harms. Mr. Combs' attorneys had stated they had not seen the new filing yet, but obviously they will respond. Now, the woman was allowed to file as a pseudonym or anonymously as Jane Doe, but she accuses Combs of sexually assaulting her while she was unconscious from drugs, and it is alleged that Mr. Combs and his acquaintances recorded sexual encounters without her permission. Jane Doe also alleges that she met Mr. Combs overseas in the fall of 2020 and that the assault and harassment continued through July of this year. Now, Ms. Doe also alleges she was often coerced and harassed into traveling to Combs' home in New York, Los Angeles, and Miami, and other cities, including monthly trips between 2021 and 2022. Apparently, allegedly, at every visit, Mr. Combs would make her perform a show for him and would supply her with alcohol and substances until she passed out. She would wake up with bruising and injuries and had no recollection of how she sustained any of these injuries. Then in July of 2022, allegedly during an encounter with Combs at his Los Angeles home, the woman alleges in the lawsuit that she was forced to ingest drugs that she believed included ketamine and ultimately blacked out. She later took a pregnancy test and told Combs it was positive. A Combs associate repeatedly demanded apparently that she terminate the pregnancy, and ultimately she had a miscarriage. Now, it's also alleged by Ms. Doe that this past July, Combs commanded her to go to his home in Miami, where she allegedly Combs shoved 2 pills in her mouth, and she says that the next morning she felt ill and confused and could not remember what had happened the night before, and that she was in the bedroom and was in complete disarray. We'll have to see how all of these allegations come out, and we'll have to see how much money Mr. Combs has to settle these things if he chooses to settle them. Now, since he has been charged, he now has some Fifth Amendment issues, so that will more than likely put a stay on the criminal cases while he remains in custody on his sexual assault and racketeering. Now, obviously, he's pled not guilty, and we'll give him the presumption of innocence as well. Well, guess what? The Sarah Boone cluster bleep continues on. With just days until her murder trial is to begin, prosecutors and the new attorneys for Sarah Boone have found themselves in a little bit of a time crunch because the new attorney wants to file motions and he needs to take apparently some depositions. Now, Boone, if you've been following this case at all, is facing a potential life sentence if she's convicted of murdering her boyfriend, Jorge Torres, who was found dead zipped inside a suitcase in the couple's apartment. Now, Boone, who admitted to zipping the boyfriend into the suitcase back in February of 2020, said that she believed that he was still inside. It was just a big joke, etc. Anyway, issues need to be resolved. There's a case management conference that was originally scheduled for Thursday, but that was postponed because of the hurricane. And so Friday got off to a little bit of a weird issue because the attorney was appearing virtually and nobody could hear anybody talking. One of the struggles with technology, obviously, convenient sometimes, inconvenient at others. Now, the issue at the motions hearing themselves comes up because prosecutors have accused the defense of waiting too long to file any motions, which still need to be heard before the trial starts. Included in the motions batch is one for a motion to suppress a 2-hour recorded interrogation of Ms. Boone at the Orange County Sheriff's Office back in February of 2020. Ms. Boone's new attorney has argued that the client's rights were violated partly because the detective did not properly read her Miranda warnings. The warning consists of 5 sentences and 2 questions read to every person questioned by police regarding the interrogation to be legally and freely given. The warning reads, "You have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to talk to a lawyer and have him represent you while you are being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questions if you wish. You can decide at any time to exercise these rights and not answer any questions or make any statements. Do you understand each of these rights? I have explained to you. having these rights in mind, do you wish to talk to us now? Pretty clear, pretty straightforward. That is the classic Miranda advisement. It is the hint, hint, wink, wink, nudge, nudge, created by the court to tell people, shut up when you are going to talk to the police. They're even saying, we'll give you an attorney to give you some advice for free. And most people go and do it anyway, just like Ms. Boone. Anyway, Ms. Boone's attorneys argue that the last sentence was never read to her, making the entire recording unusable as evidence. Don't believe that is the law, but the judge is going to have to decide. You have to view the Miranda advisement in the totality of the circumstances to see whether somebody understood them. The video will be the best evidence for that. I believe the confession, the statement by Ms. Boone, will come in at trial. Anyway, the judge is clearly frustrated and reiterated to both parties that the trial date was quickly approaching and gave Mr. Boone's attorney, this new guy, until 11:59 p.m. on September 27th to file any further motions to suppress. And the attorney said, well, we'll do our best. No, you have to comply. Anyway, Mr. Owens, the attorney for Ms. Boone, has also filed a motion asking for Ms. Boone to have makeup and for her hair to be styled for her at trial, liking doing so to having a male inmate shave before court. Responding to that request, prosecutor said in court on Friday, as far as I know, she'd be the first person to ever have that done in this courthouse. Ms. Boone's attorney also noted that would be wearing clothes from the public defender's office. Instead, he would be getting her clothing, mentioning that he would be getting her measurements next week. So he's going to run out to wherever to get her clothing. Listen, normally when female prisoners, defendants show up, they usually get access to curling irons. Heck, they make lipstick. They give them this stuff. But to think that you have to apply all kinds of makeup, yeah, that's probably not going to happen. We'll see what the judge's final rulings will be. All right, we brought you the case about the Mississippi teen last week, and she's filed an appeal, basically a motion for new trial. I don't know. We'll see. Were the attorneys ineffective? I don't know. Let's see. The attorneys for a teenage girl sentenced to life in prison for murdering her mother and trying to kill her stepfather has filed an appeal citing new evidence and a series of errors at trial. This is basically a motion for new trial at this point. So as we brought you the story, Carly Gregg, who's only 15, was sentenced by a jury, which took less than 1 hour to decide that she should spend the rest of her life behind bars after finding her guilty of murder, attempted murder, and tampering with evidence. Now, in this new motion filed on Friday by Carly's attorneys, they're asking for a new trial or the alternative for the jury verdict and sentence to be set aside entirely. Now, at her trial, Carly's attorneys conceded that she had killed her mother and shot her stepfather, but argued that she was legally insane at the time of the crime and had been suffering from an undiagnosed mental illness. All right. A psychiatrist hired by the defense testified that she had an unspecified psychiatric disorder. So in her motion, defense attorneys said that new evidence came to light after the trial, adding further weight to that diagnosis. This is where it gets really interesting, why the attorney is potentially ineffective. According to the attorneys, a reporter from a news channel contacted the defense team after they interviewed Carly's biological father, a guy by the name of Kevin Gregg, and talked to the television station during this interview. In that interview, the dad told the reporter that his daughter had suffered from auditory hallucinations as a child and was put into equine therapy as a result. So the motion notes, however, that Kevin Gregg refused to cooperate in the defense process for the defense team and refused to talk to the state as well and refused to talk to the mental health professionals evaluating Carly and refused to come to any pretrial hearings or a single day of the trial. It's weird that this guy, the dad, refused to cooperate with the mental health people, the defense, and the prosecution, but he would talk to the news reporters. Very odd indeed. Now, is this new evidence? Well, potentially, yes. I'm assuming the mental health professionals would have got records going back to when the child was receiving all this therapy, or his own client would have mentioned it. So really the question is this something new that was not available to the defense team, that they just couldn't have figured out any other way? I think the motion's going to get denied. the defense team's motions raises an issue with a comment from a Dr. Rebecca Kirk, Carly's former counselor and witness for the prosecution. The prosecutor specifically asked Kirk about her notes, indicating that Carly wanted to read Fyodor Dostoevsky's Crime and Punishment, which everybody said is irrelevant to the case and was introduced only to prejudice the jury. Among the other issues cited in the motions were radical sanctions placed on the defense by the judge in response to what he found were willful violations of discovery, which included excluding 2 witnesses and limiting the testimony of other witnesses as well. The motions also questioned the jury verdict based upon the makeup of the jury, pointing to the defendant's young age. Under Mississippi law, jurors must be 21 years old, meaning Carly was much younger than her peers who decided her fate. Mississippi believes only a person 21 or older possesses the maturity necessary to make decisions about the life of another. However, Mississippi also holds that a 14-year-old or 15-year-old possesses the maturity necessary to make decisions about a plea offer, understanding the nature of the alleged offenses, comprehending the nature of the charges against them, effectively participating in their defense at trial, and face the same lifelong sentences as an adult. The defense notes that these 2 fundamentally opposing legal standards cannot be rectified. Now, there's been no hearing date set, and when I mean this will more than likely be denied, I mean by the trial court. Trial courts don't like to reverse themselves. They're not going to say, I screwed up. They're going to say, let the appellate courts tell me I did something wrong. So we'll have to wait and see. Now, lots of big issues there, lots of legal issues, due process issues. This case is going to be making its way through the appellate courts for years and years to come. It could ultimately even make its way to the United States Supreme Court. Next on the docket, guess what the pediatrician assistant was charged with? That's right. A North Texas pediatric medical assistant is accused of molesting children who are under his care. Irvine police arrested 25-year-old Angel Nunez on an indecency with a child charge on September 5th. Police say the pediatric clinic where Nunez worked contacted authorities after learning he allegedly molested a 14-year-old boy, claiming it was medical care. Now, police first received a tip back in August suggesting Nunez had inappropriate sexual contact with multiple children at the Little Spurs Pediatrics in Irvine, Texas. These patients believe they were receiving medical exams and were not aware at the time that they were actually being abused. In an arrest affidavit, one of the incidents states that Mr. Nunez gave a 14-year-old boy a hernia exam during a sports physical and touched his genitalia, even though he was not trained to give that type of medical exam and was not authorized to do so. Part of the duties were to take vitals and things like that, but he's not a physician. Anyway, when questioned at the Irvine Family Advocacy Center, the victim claimed Nunez took him into a second exam room away from his mother, saying he needed an eye exam. But once the two were alone, Nunez asked him to pull down his pants for a genital exam that lasted about 2 minutes. If anyone's ever been through those sport exams, it's a quick turn your head and cough kind of thing. Doesn't take 2 minutes. Anyway, a security video from the pediatrician's office confirmed that the boy had been taken into the second exam room alone with Mr. Nunez. Now, Mr. Nunez has been at the Little Spurs Pediatrics for about a year, and he was fired in August. Now, in addition to working there in Irvine, he also worked at offices in Grand Prairie, Arlington, and Fort Worth locations. So if you went there, better have that big talk with your kids. Obviously, we'll give him the presumption of innocence, and it doesn't sound like the medical office would condone or knowingly permit that to take place whatsoever, but they're more than likely going to get sued. I bet they didn't check him out before they hired him. Anyway, next on the docket, do you really need a dental license to practice dentistry? I mean, are we really just being a little too, restrictive of things like that? Anyway, police are looking for a Katy, Texas woman who was practicing as a dentist and actually injured patients. And it turns out she didn't have a license or probably ever went to school. So at the time, the suspect was out on bond for a charge of felon in possession of a weapon and was accused of a shooting also back in 2023. So the police in the Houston area are seeking information on the location of Juanita Solomon, who allegedly acted as a dentist without a license and, like I said, caused some harm to some patients. She apparently accepted patients under the practice of Smiles Cosmetic Design. Smiles, of course, is spelled S-M-I-L-E-Z, and design was D-E-S-I-G-N-Z. Okay, any dentist that's going to open a shop like that has got to be a big red flag right there. Well, apparently this is not her first problem with the law. Solomon was out on bond, like I said, for the possession of a weapon as a previous offender. In 2016, she was convicted of a felony offense for delivery of a controlled substance back in December of 2016, and then accused of shooting her boyfriend's ex-girlfriend in July of 2023. Anyway, Juanita Solomon is the definition of a career habitual offender. She's been in prison multiple times in different counties, and is no surprise she is once again, according to the local sheriff. Her latest offense is extremely brutal, pretending to be a dentist, causing undue pain and stress to individuals. So the quicker we can get her back in custody, the less that anyone has to suffer. Now, a victim reported her to the Houston Police Department after they were injured by a dental practice and the dentist who introduced herself as Nikki Calloway. She failed to show up for a follow-up appointment to address the patient's concern. The victim identified Calloway as being Miss Solomon. Now, according to authorities, injuries to the patient include pain, bleeding, and even one tooth just happened to fall out. Now, court records state that a patient visited Solomon for dental services after finding her on TikTok. Solomon had sent a woman, a quote for $1,000 to replace 8 bottom teeth and 8 front teeth, plus $350 for a bridge. Solomon never took a mold for the dental work and later used a drill and file as well as some chemicals on the woman. And guess what? The Texas Board of Dental Examiners confirmed that Miss Solomon does not have a license to practice dentistry, nor has she even worked as a hygienist or as a dental assistant. Like I said, if you're meeting your dentist on TikTok, I guess, and they spell designs with a Z, run. And the price seems too good to be true, run, ladies and gentlemen. Yes, true threats. Now, political rhetoric can get a little out of hand, but this is taking it just a little bit too far. So a former candidate for Congress in Florida has been charged with threatening to kill his opponent and the eventual winner in the race. That would be U.S. Representative Anna Paulina Luna back in 2021. This relates back to a Republican primary race at the time. So this William Robert Braddock guy faces up to 5 years in prison if he's convicted, according to the charging documents. Although prosecutors don't name Miss Luna in the press release, she has previously filed for a protection order against Mr. Braddock. And the defendant is alleged back on June 8th of 2021, allegedly threatened to injure and kill Miss Luna and an associate during a phone call. Prosecutor said he was going to call up his Russian-Ukrainian hit squad and make his opponent disappear. After making the threats, Mr. Braddock must have realized that it was not a good thing to have said, and he ultimately fled to the Philippines, where he was ultimately arrested and has been recently deported back to the United States. Anyway, Ms. Luna and Braddock were running mates back in the Florida's 13th Congressional District to replace the then Representative Charlie Crist after he vacated his seat for his unsuccessful bid to be governor. Luna won the primary and then the general election. She filed for a protection order back in 2021 after he made the alleged threatening calls. Like I said, Braddock faces a charge of interstate transmission of a true threat to injure another person. And this case is being prosecuted by the federal government. There you go, ladies and gentlemen, because they have a unit. They have a unit where they take up threats. It's called the Justice Department's Election Threat Task Force, which aims to address threats of violence against people in the political arena, whether elected officials or election workers. I got an idea. Let's just not make threats. Let's not call each other names. Let's, have a political debate based upon something radical like the actual issues. Could you imagine such a thing? It'd probably be absolutely boring, but at least we would know what was going on. Next on the docket, this day in legal history. On September 30th, 1946, the International Military Tribunal, constituted by the Allied powers in Nuremberg, Germany, found 22 Nazi leaders guilty of war crimes committed during World War II. So there you go, ladies and gentlemen. Now you know. And our dumb criminal of the day. All right, so a video was posted on TikTok back on early September, and it shows a clip from a Zoom recording of a court hearing and an interaction between Texas District Court Judge Stephanie Boyd and a woman who appears to be the mother of a defendant. Now you can see the woman is in a blue blouse and white shorts, carrying a cell phone and a tote bag as they approach the podium. The judge asks, "Why are you in this courtroom in shorts?" The mom responds, "I'm sorry, I never really been in court." The judge asks her to hand her phone over to the deputy in court, then asks the deputy to delete a photo the woman had taken in the courtroom. "Okay, who are you taking a photo of?" the judge asks. "Oh, I was just letting my daughter know my son's okay." "No, who are you taking a photo of?" the judge asks again. "My son, Rick," the woman finally admits. "All right, deputy, if you can put her in cuffs since you want to be next to your son, put her in the box." The woman then immediately apologized. "I apologize, ma'am. I didn't know." "I do appreciate your apology," the judge responds, "but guess what? You're going to go to jail. It's called contempt."
Excuse me, the lady. Excuse me. You come forward. Yes, come. No. Come forward. First of all, why are you in this court in shorts?
I'm sorry, I was just, I don't know. I've never really been in court.
All right. Second of all, turn your phone over to the deputy. Do not close it. Deputy Laura, if you'll delete whatever photo she took, please. All right. Who are you taking photos of?
Oh, I was just letting my daughter know my son's okay and that he.
No, my question is, who are you taking photos of? All right. So Deputy Laura, if you put her in cuffs, since you want to be next to her son, and put her in the box.
I apologize, ma'am. I
appreciate your apology.
I didn't know.
All right.
Put your phone in picture of that.
And who is Rick in the box?
He's with Charles Monk.
All right. Well, I'm sure Charles Monk will come back and take care of you, but for now, you're going to be in the box.
Now, Judge Boyd has been on the bench since 2019 and is known for her candor and frank conduct in criminal court proceedings that she oversees. Now, this video interaction with the woman garnered about 17 million views, and it's unclear what the hearing was for, other than it was for a case about her son. But some people thought that the judge was a little harsh on the woman, and I say no. There's a certain level of etiquette that's expected in court, all right? So this woman, unidentified woman in Texas, showing up for her son's court case in shorts. Let me give you a quick rundown on little courtroom etiquette, okay? Because you are a dumb criminal today, and we're trying to prevent people from doing that. First, now not everybody has a suit and a tie, but I assure you, would I love to not have to wear a suit and tie every day I have to go to court? Yes, but it's out of respect. Even if I didn't, I would still try to present myself well in court. You would be surprised how many judges say, I appreciate somebody actually looking like they cared and had respect for the proceedings coming to court. Everyone notices. Why? Because most people show up looking like they just changed the oil on their car and they have no respect for the process. It used to be judges would send people home if they were not dressed appropriately. I remember having to say, Judge, my client apologizes for his appearance today in court. He's come directly from work. He was running late. He could not make it home to change, and it meant no disrespect to the court, and the judges would usually accept that. But now everybody shows up looking like they're changing the oil in their car or that they're going out clubbing at night. It's unbelievable. And I hope you're never a defendant, but if you are, try to dress appropriately for court. And even if you are completely indigent and have no money, try to look your best. I assure you, it will be noticed and it will be in your favor. And another thing, don't take any photographs in the courtroom. Most courtrooms have it on their door. You can't videotape. You can't take photographs of anybody. It's a security issue. And that's why this woman got arrested for contempt, because she took a photo in a courtroom and there must have been an order on the door saying, don't do that. I'm telling you, ladies and gentlemen, I'm not trying to be this to sound like some old curmudgeon. I'm just telling you what I've seen and what works over the years. All right, that's all we have for you today. Have to run to court. Have a wonderful day. We'll see you next time on Crime Talk. And remember, yes, the Constitution matters.